Welcome and good afternoon. I am Janine Zweig, Associate Vice President of the Justice Policy Center in the Urban Institute. Before I jump in, a few notes on housekeeping. This event is being recorded. The recording and relevant links will be posted online after the event. Live captions are turned on. To turn off the live captions, click the live transcript button at the bottom of your screen. All participants are muted. And if you'd like to join the conversation on Twitter, please use the hashtag #LiveAtUrban. With the logistics behind us, I want to thank you for joining us. Thanks to our speakers for joining us as well, from the Philadelphia District Attorney's Office, the Amistad Project, and a participatory defense expert. Another note of thanks to my colleagues here at the Urban Institute, Andrea Mattei, Lee Courtney, Lily Robin, and Ivy Hunter, for putting on this event today. Lastly, thank you to our funder, the Institute for State and Local Governance, or ISLG, and MacArthur Foundation for allowing us to delve into this important topic of plea bargaining. With our criminal legal system overwhelmingly relying on plea offers to resolve cases, we know little about what motivates and influences key actors in the plea bargaining process. This exploratory study that we'll be learning more about today is a start to our understanding of the plea bargaining process. We hope it will provide rich context that can inform other studies in the future and inform practices in other offices. Now I'd like to introduce Jennifer Ferrone. Jennifer is an Associate Research Director at ISLG, leading a portfolio of research projects related to criminal legal system reforms, including prosecutorial decision-making. She'll also be moderating the panel today. Jennifer, we're so excited to have you.
Thank you, Janine. Good afternoon, everyone. I'm really excited to be here with you today. As Janine mentioned, I am an Associate Research Director at the CUNY Institute for State and Local Governance, and we are a New York City-based research and policy think and do tank. I just wanted to briefly provide a bit of context about how this project came to be before I hand it over to the lead author, Andrea Mattei, to provide a project overview and summary of findings to really set the stage for the panel discussion that will follow, and that is the main event for today. Since 2015, ISLG has been providing research and data support to the MacArthur Foundation Safety and Justice Challenge, a national effort that seeks to reduce the misuse and overuse of jails in America. The SJC has supported over 50 jurisdictions across the country to implement a wide variety of criminal legal system reforms that target the main pathways to jail in order to reduce reliance on local incarceration and address disproportionate impacts on low-income individuals and communities of color. Leveraging the collective work of SJC sites and a robust collection of data that has been gathered since the SJC's inception, the Foundation has also committed to a research investment strategy that aims to advance a research agenda that will provide knowledge to the broader field about what works to reduce reliance on incarceration and to reduce jail populations, reduce racial and ethnic disparities, and improve pretrial systems of justice. To do this, since 2019, ISLG has been managing a research consortium of pre-qualified research organizations that are eligible to bid on research projects developed by ISLG with guidance and support from the Foundation and an external research review committee. The Urban Institute is one of 11 consortium members, and the work that you'll be hearing about today emerged from the consortium activities. The consortium operates under a number of different priority areas, but one of which is to develop a better understanding of the factors that drive decision-making, particularly at the front end of the system, including at the point of prosecution. As we all know, prosecutors heavily influence key stages of criminal legal decision-making. However, due to the relatively limited amount of information we have available with respect to the plea process in particular, ISLG really wanted to develop a portfolio of work that was centered on unpacking the black box of this stage of the system. As Janine noted, an overwhelming majority of cases are disposed by plea, and prosecutors really do have a lot of power during the negotiation process. To learn more about the process and its impacts on case-level outcomes and racial disparities, 2 projects were awarded funding under the portfolio covering 3 SJC sites. Today, we'll be focusing on the work that Urban has been conducting in Philadelphia. The main event for today is to welcome panelists into a broader discussion about the plea bargaining system. But first, Andrea will now briefly review the findings of the study, which a report was released today. Very exciting, and we're going to be putting the link in the chat for you all to access later on. So with that, I'll turn it over to Andrea.
Thank you, Jennifer. Good afternoon or good morning for those joining. Like Jennifer said, my name is Andrea and I'm the principal investigator for the study, but it really took a village of people to work on this project, including Lily Robin, Kelly Roberts-Freeman, and Lee Courtney, who will actually be concluding this webinar. We'd also briefly like to thank our funders, the Institute for State and Local Governance and the MacArthur Foundation for their support of this project. We'd also like to thank the Philadelphia District Attorney's Office for opening their doors to us, and to all those who spoke with us and provided their important insights throughout the project. You can go to the next slide. Pleas make up the wide majority of guilty dispositions in our criminal legal system, as Janine and Jennifer both mentioned. I'm paraphrasing Justice Kennedy here when he says that a system of pleas has largely replaced a system of trials. Plea bargaining is such a hidden process, and though we know that prosecutors are very involved in it, we know little about how they make their decisions and why around plea bargaining. This is particularly relevant now when our country seeks to learn more about the criminal legal systems and the actors within it. Moving on to the next slide, our study was an exploratory descriptive one. We had one single site, which allowed us to go deep into an unknown topic, but did limit us in our generalizability to other fields. However, findings from this report could develop rich context that can inform future studies and practices in other offices. As for our approach, we took a mixed methods approach, and our data collection activities consisted of a policy review, which includes a 2017 ADA handbook, ADA meaning Assistant District Attorneys, which I'll use as shorthand because it's going to take a lot longer to go through ADA, the full length throughout, and office-wide policies enacted after DA Krasner took office. We also had an administrative data analysis, which included court data from 2018 to 2021, though we analyzed the COVID year separately. Additionally, we had a case file review of 115 cases that were disposed by negotiated guilty pleas, a survey of ADAs in which we received 65 responses for a response rate of about 29%, and interviews with 11 ADAs, 9 defense providers, and 5 people who previously accepted pleas in Philadelphia. All these research activities led us to answer 10 research questions, which we'll go one by one through. You can bear with me because I know that's a lot of questions. Ivy, you can go to the next 2 slides. The first research question is, what policies, practices, and guidelines exist around plea bargaining, and how do they impact prosecutorial decisions? We found that ADAs have a lot of discretion in their plea bargaining negotiations, and this discretion is guided by supervisory control, which can vary by unit, office-wide policies, the Pennsylvania sentencing guidelines, which ADAs often use as a guide for crafting their plea offers. Of those office-wide policies, 2 are particularly relevant for plea bargaining decision-making. The first being that ADAs should try to offer pleas, when applicable, with terms shorter than the lower end of the sentencing range for certain offenses, or seek its supervisory approval to offer sentence lengths above. It also states that if sentencing guidelines recommend less than 2 years of detention for a crime, the ADA should proceed with an alternative to incarceration. Another major policy is DA Krasner's mass supervision policy, which institutes an office-wide goal for an average community supervision period of 18 months or less for felonies and an average of 6 months or less for misdemeanors. 62% of ADAs surveyed stated that they didn't receive training on plea negotiations or crafting offers. Additionally, the amount that the Pennsylvania sentencing guidelines mattered depended on each individual ADA. Some only used it as a jumping off point, whereas others said that they followed it closely to craft their pleas. Moving on to our next question, which is, what are the overarching goals that influence plea practices and how is performance assessed? The ADAs identified providing justice to victims, defendants, and the community as the most important goals for plea bargaining. And following that were goals related to efficiency. The problem we saw in our research is there are very few mechanisms to assess performance and whether these goals are being achieved. We do know that there is one policy that was assessed for compliance, and that was an office-wide goal instituted by DA Krasner to provide caps on maximum community supervision terms. That's the policy I mentioned in the last slide. The DA lab at the District Attorney's Office did a report and found that compliance was high for this policy. 2/3 of negotiated felony pleas and 3/4 of negotiated misdemeanor pleas are within that goal range for their supervision policies. So there are ways to assess compliance to office-wide policies. A majority of ADAs in our survey said that there were no checks in place to assess whether a plea offer was too lenient or too harsh. Less than a quarter of ADAs surveyed said that there were checks, and when they were asked to identify what they were, about half of them said supervisor, another 28% said the judge, and 9% said the media or the public were the checks. However, there needs to be further research on whether these actors actually do provide checks on prosecutors during plea bargaining. The next slide breaks down our results around those goals. These goals were further broken down by unit, and we found that the major trials unit and the pretrial unit had larger percentages of their ADAs, responding that goals related to time efficiency were important or very important relative to other units. As we'll see later on, this makes sense since the major goal for the pretrial unit in particular is to dispose of cases as quickly as possible. Moving on to our third research question, how do plea bargaining approaches vary, and to what degree do they lead to desired outcomes? Each unit has their own approach to plea bargaining depending on the unit's philosophies, unwritten norms, and current supervisors. For example, the juvenile unit is known for having a more rehabilitative approach to case resolution to limit the impact of the criminal legal system on youth. The pretrial unit has a unique approach, as I mentioned earlier. They exercise more discretion, and their goal is to dispose of as many cases through pleas as possible. ADAs in this unit are also highly experienced and have long tenures in the office. We also asked about changes to approaches during the pandemic. Many ADAs, though not the majority, said that they offered more lenient pleas since the start of the pandemic, with the most common reason being that the victim is no longer willing or able to testify, followed by other reasons related to the health of the defendant. Part of this research question that we see here asks, to what degree do these approaches lead to desired outcomes? We didn't get a chance to analyze this in the administrative data due to limitations that we'll discuss later, but we were able to ask in our survey about one of the stated goals, providing justice to defendants. We asked ADAs how often they believe people who are innocent accept pleas, which is in theory a miscarriage of justice for the defendant. Almost half of ADAs who responded said that defendants sometimes or often accept pleas when they're innocent. Only 6 said that this never happens. Moving on to the next slide. This begins our quantitative analysis section. Our first question was, what data on plea offers is available? Shockingly, although not shockingly to a lot of researchers on this call, data on plea offers is very limited. We were given access to administrative data provided by courts and a case file review provided by the DA's office. The administrative data from the courts included some information on whether a case was resolved by negotiated plea and what that sentence was. We also get additional information from cases that were resolved in the Court of Common Pleas, which is where most plea bargaining occurs in Philadelphia, and where felony cases are resolved. These cases record information that are helpful for sentencing guideline calculations, including prior record scores, which is the defendant's criminal history, and offense gravity scores, which rates the seriousness of the offense. Importantly, this information does not include data on the substance of the plea negotiation, including how many offers were made and the terms for each offer. The best source of data on plea offers that we came across were from case files. Some of these case files do have prior plea offers, though it's not consistently inputted. This is partially because plea offers are often extended between prosecutors and defense in emails and phone calls, and not documented consistently beyond that in case management systems, for example. Our next research question is, what are basic trends in plea outcomes? First, from our administrative data, we found that 69% of convictions are from negotiated guilty pleas. The majority of negotiated guilty pleas in the Court of Common Pleas resulted in an outcome including incarceration. And almost 90% of all negotiated guilty pleas in the Court of Common Pleas included a term of community supervision, which averaged at about 2.5 years long. Cases that resulted in negotiated guilty pleas took less time to resolve than cases that resulted in other guilty or no contest outcomes, including trials. From our case file review, we found that many plea offers did not change over time, but of those that did, they generally received more lenient offers. We also found that people who were detained pre-trial generally received worse plea outcomes, including longer periods of incarceration than those who were released pre-trial. However, differences in prior record score and offense gravity scores for people who were detained could be contributing to these changes, since 2 of those markers are used to often find a recommended sentence in the Pennsylvania sentencing guidelines. Moving on to our next research question, which is, how do plea offers and outcomes vary by a person's ethnicity and race and other demographic characteristics? There were no noticeable differences in age between people who accepted negotiated guilty pleas and those with other guilty or no contest dispositions in our administrative data. There were, however, differences depending on race. In our case file review, we found that larger proportions of Black people who accepted pleas received outcomes including incarceration than white people. Additionally, Black people received longer sentence lengths on average than white people. This is all complicated by the fact that structural racism heavily impacts the sentencing guideline matrix, which is often used as a baseline in plea negotiations. Specifically, the guidelines rely heavily on a defendant's prior record scores to calculate a recommended sentence, which we know structural racism can impact depending on policing practices. Moving on to our next slide. This research question asks, if racial disparities exist in plea bargaining, what factors contribute to these disparities? Over 80% of surveyed ADAs agreed that structural racism is present in the criminal legal system in Philadelphia, and it can impact plea offers. When we asked to explain why they believe this, several cited policing practices, defendant criminal history, and implicit bias as contributors to racial disparities in plea outcomes. Specifically, implicit bias came up in how ADAs interpret defendant characteristics as either mitigating or aggravating. For example, how remorse is conveyed varies by culture, and interpretations by an ADA of a defendant's expression of remorse can lead to worse or better outcomes for that defendant. Moving on to our next research question, how is an initial plea offer made and what types of factors influence that offer? Not surprisingly, how strong the prosecution's case is, including admissible evidence, is one of the most important case level factors that can impact the plea offer, along with the nature of the offense. 4 ADAs we interviewed said that they would offer more lenient pleas if they felt their case was not strong, evidence was often inadmissible, or the case would not hold up in trial. However, 4 people that we interviewed who accepted pleas in Philadelphia said that one of the reasons that they accepted the plea offer was because of how lenient it was, despite one of them asserting their innocence. This raises a potential ethical concern about making lenient offers in weaker cases. The case could be weak because the defendant is actually innocent of the charges. As for defendant level factors, ADA said that a defendant's criminal history, immigration status, and attitude or remorse are particularly relevant when crafting a plea offer. All ADAs said that they would consider mitigating factors, including education and employment, among other factors. ADAs reported being more likely to offer a plea with incarceration if the person had already been detained pre-trial. This is partially because they're anticipating that judges would not want to incarcerate someone who had been out of custody and stayed out of trouble. So our next question is, how do prosecutors make decisions about changes to plea offers throughout the plea bargaining process? Though most ADAs said that plea offers stay the same over time, some ADAs perceive that they become more lenient with changes in evidence. And this follows what we saw in our case file review, as we mentioned earlier. 84% of ADAs reported that they'll make both charge and sentence bargains as concessions. And finally, ADAs believe that leniency for defendants do not extend to trial, as they generally believe that defendants will face a trial penalty. Moving on to our last research question. Thank you all for bearing with me. 10 research questions is a lot. But moving on to the last one, which is, what are the perceptions of defense providers and defendants regarding plea negotiations and outcomes? People going through the criminal legal system need more information and time to properly understand the consequences of accepting a plea. Pretrial custody, long case processing times, and the risk of trial all had coercive effects on people accepting pleas, as some that we interviewed reported. Additionally, those that we interviewed who accepted pleas said that they would spend months waiting for a court appearance, but only have 15 minutes to decide whether they wanted to accept a plea or not. This made them feel like a number rather than a person. Defenders and people who accepted pleas that we interviewed reported that the judge assigned to their cases, and particularly their reputation for sentencing and trial penalties, had a large impact on their decision-making for whether to accept a plea or whether to recommend that their client accept the plea. So, moving on to recommendations, what does this mean for that? What do these findings mean for what we recommend? On to the next slide, our findings suggest the following reforms, which are specific to Philadelphia, but can be applicable to other jurisdictions. First, there should be standards for recording plea offer data in prosecutor and court case management systems, including recording the terms of each offer extended, the date of the offer, and whether the offer was accepted. This will allow the research field to dig deeper into questions like whether prosecutors are actually reaching their goals with plea bargaining. There could also be more mechanisms in place to examine adherence to office policies on plea bargaining. We know they can do this. The data lab has already assessed compliance on their community supervision policy, but the office could benefit from having more consistent and official mechanisms in place to make sure that an offer is following policy wherever applicable. ADAs would also benefit from having proper training and continuous communication of office-wide policies related to plea bargaining. Additionally, prosecutors should consider withdrawing cases where there's weak evidence rather than extending coercively low plea offers. And finally, efforts should be in place to mitigate heavy trial penalties, which are coercive factors for people accepting pleas. So finally, moving on to the last slide, this concludes my monologue. I appreciate everyone hanging on to this more boring and technical portion of the webinar, but we're finally moving on to the panel discussion next. My email's here if anyone has any additional questions, but I'll pass it back to Jennifer for now.
Thanks, Andrea. So I'd like to welcome our panel now. We do have a series of questions that are prepared for the panelists, but if time allows, we'd love to take some questions submitted by the audience, and you could use the Q&A feature to do that. I do see a couple of questions coming in already. Well, we might answer those as we go along, but then also we'll try to turn back to it at the end. So first, I just want to kick things off with some introductions of our panelists. So first we have Steve Austin, a participatory defender from Mothers in Charge. So Steve devoted his life to being a frontline advocate for improved prison conditions and has served as a peer specialist where he facilitated violence prevention, anger management, character development, thinking for a change, citizenship, and batterers classes for over 30 years for both youth and adults. After 42 years in prison, he was released in 2017 and became connected with Mothers in Charge, where he immediately began volunteer work facilitating participatory defense, which is a community organizing model designed to help people with cases understand and navigate the criminal justice system. He quickly became the director of the program, and while doing this, he received his Associate of Art degree at 60 years old in Human Services from Harcum College. With the National Institute of Corrections certification, he is also a CLE trainer for Philadelphia attorneys, a tenacious criminal justice reform advocate, a proponent of No Child is Born Bad, and committed to abolishing life without parole sentencing for juveniles in the United States. Next up, we have Oren Gur, Director of Research from the Philadelphia District Attorney's Office. Oren joined the DAO in 2018 to use data, research, and criminological theory to plan and implement policy and transform Philadelphia's legal system. Dr. Gur has led grants of more than $4.9 million during his time in the DAO, including to create the Data Lab, a new unit that supports policy, practice, and research into the impact of prosecutorial discretion on individuals and communities. Oren's work has included prosecutor-led bail reform, sentencing reform to reduce mass supervision, harm reduction policies for people who use drugs, and the Interagency 100 Shooting Review report on shootings and gun violence, and facilitated independent research on topics including bail reform, accidental drug overdoses and criminal justice contacts, the resentencing of juvenile lifers, diversion for misdemeanor offenses, and more. Next, we have Chris Henderson, Executive Director of the Amistad Law Project. They grew up in East Orange, New Jersey, a majority Black working class community. Their educational career began in East Orange's underfunded schools, continued at a private Christian school, and led to a boarding school in New England for high school. Their diverse educational experiences and the realization that a quality education is possible, but often incredibly expensive, led them to work towards making sure we all have what we need. They are a movement lawyer, a co-founder of Amistad, and a co-founding member of the Coalition to Abolish Death by Incarceration. They are on the steering committee of Free the Ballot, Incarcerated Voter Family Network, and on the board of directors of Black Youth Project 100. They are a 2018 Law for Black Lives and Movement Law Lab Legal Innovators Fellow and a 2019 Soros Justice Fellow. Finally, Andrea Mattei, Policy Associate from the Urban Institute, which you just heard from, also is on the panel. She leads other projects related to prosecutorial data collection in smaller offices and also a national scan of prosecutor-led diversion programs. Andrea is also managing an evaluation of the DC Office of Attorney General's Restorative Justice Program. And prior to joining Urban, she worked at the ACLU of Michigan, where she spent time as a court watcher, advocating with the legislative office to abolish juvenile life without parole, and conducting research for a civil rights case on the sex offender registry. So I'd like to welcome the panel. Thanks so much. So we have about, I would say, 20 to 30 minutes of discussion. So I'm going to jump right into some of our questions here. But my first question, and I want to direct this towards Oren, just because the work was done, in partnership with the DAO. But just what were some of the main takeaways that you took from the report, and what really stood out to you from the report?
Thanks, Jennifer, for the question, and hi, everybody. I want to start by thanking the Urban Institute, the MacArthur Foundation Safety and Justice Challenge, and the Institute for State and Local Governance for supporting this work at the institutional level, and Andrea, Kelly, Lily, and Lee for undertaking this independent mixed methods study. I also want to thank the assistant district attorneys who participated in the interviews and survey, as well as Michaela Smith, Michael Hollander, and colleagues in the district attorney's transparency analytics lab, or data lab, for helping make this project happen. And of course, DA Krasner and leadership team for letting it happen. And with that, I'll note that the views I'll express today are mine and don't necessarily reflect those of the office. So in terms of main takeaways, I identified three, just to talk about at a high level. I really appreciated the finding about the need for more and better data and data systems. I think this is an issue in Philadelphia, in our office, and more broadly, and also a national issue that many prosecutorial offices face. So I really appreciate you all underscoring that particular need in this space. Similarly, I thought the research was really strong because of its mixed methods approach, having both the quantitative data and also the qualitative interviews and discussions, both with people in our office and people outside of our office, to get different perspectives on plea bargaining was really helpful in providing more context and detail to some of the quantitative findings. And I think kind of similar, one of the big takeaways is that we also need a mixed methods approach to policy, right? So I think some of the findings and some of the takeaways, for example, addressing coercive impact of pretrial custody and case processing times noted by defense providers and defendants, those can be achieved through bail reform, for example, or through broader system reform that will also hopefully achieve improvements in the plea bargaining space. So again, the need for better data and data systems, the benefits of the mixed methods approach, and then also thinking about policy that way and thinking about different policies that you can do that will also have an impact on plea bargaining. So again, thank you for including me, and I look forward to the discussion.
Great. And Steve, how does this align with your experiences and observations of Philadelphia's legal system? I think you're muted, so you just need to unmute.
Sorry.
That's okay.
Good afternoon, everyone. Thank you for having me here. Thank the Urban Institute for doing this study. It's a good study, and I read the full report, and a lot of the information in here is very powerful. But things that how it aligns with me is one of the stated objectives initially here was to learn more about the policies and practices guiding prosecutorial decision-making in plea bargaining, and also to examine how it can impact plea offers and outcomes. I think that, for me, that encapsulates this plea bargaining system that we have here in Philadelphia. And folks who accept pleas and the policymakers and the decision makers and the accountability factor, where the policies coming from, who's responsible, and how can we identify them more carefully. It was stated also earlier that there's no real process in place to collect this data and this information. And that's something that I think we need to do more of, or we need to encourage. I also see an opportunity where one of the findings in the study reports that ADAs felt that their discretion in plea bargaining is somewhat constrained by sentencing guidelines, supervisory control, and office-wide policies. Again, those types of things need to be identified. If they can be identified, then we can establish some degree of accountability, and we can speak to and work with the district attorney's office in establishing a broader program that allows us to engage possibly the community, which I think there's been more of an effort to do through some of the criminal legal system processes. And hopefully we can identify that, the policies and who's responsible, and make suggestions and changes that will benefit most folks.
Great. Chris, do you have any thoughts about what stood out to you on the report?
I think, kind of the first thing that comes to mind is just the fact that this research was possible in the first place. There are a lot of offices across the country that wouldn't allow this kind of research to happen. It's something that we've really seen under District Attorney Larry Krasner, this desire to have the data, to know what actually is and isn't working in real time.
Yeah, that's a great point. And while you're still speaking, I'd like to hear from you too, to kind of let us know what steps you feel the DAO should take to confront and address the racial disparities that show up in the plea bargaining process and in plea outcomes.
I appreciated in the report the sort of suggestions around that, around there being clearer policies, and like a clearer sort of like, I don't want to say hierarchy, but like this idea of like, these are the people who are ultimately responsible for pleas, and then also actually tracking that data better going forward, so that more research actually is possible to see that yes, at every level of the criminal legal system there are racial disparities, but also like what that actually looks like, and how that actually impacts people's lives. I think would be like really great information to have.
Jennifer, can I add something to that?
Of course.
One of the things in the report also talked about the sentencing guidelines and how big a role the sentencing guidelines play in the process, and that pre-trial detention significantly increases a person's likelihood of accepting a plea deal. So going back to what Oren said earlier here about certain things could be addressed through the bail process, these are things that we need to keep our focus on because they're connected. They're connected in such a way that it really does affect the process significantly.
Yeah, and Andrea, I know, during kind of writing up the report and, thinking through the findings that, you were seeing in the data and through your interviews, what do you think prosecutors could do to mitigate some of the systemic racial and ethnic disparities that they say are baked into the cases they receive? So such as the cases that are coming to them from police practices, or, in thinking through defendants' prior records, and then also, the guidance that shapes their decision-making, like the sentencing guidelines, as Steve just mentioned.
Yeah, I think Steve and Oren made a fantastic point that it is multidimensional. There's a lot of aspects to prosecutorial decision-making, a lot of different points that can also contribute to and impact decision-making, but there's also different actors as well. But beyond that, to stick with your question, as a start, prosecutors need to consider how racial and structural racism is impacting what they're seeing directly in front of them in their case files. For example, criminal history, which is considered in sentencing guidelines, is often based on policing practices, as we know. And prosecutors did acknowledge this in the aggregate, but it's about seeing this in individual case files as well. Additionally, there's some implicit biases that prosecutors bring into their work, as we all bring into our work, that aggravate racial disparities. Ambiguous mitigating circumstances like showing remorse or thinking someone looks like a good guy can heighten racial disparities. And there's policies that can be put in place to put bounds on these ambiguous factors. And it's also important to educate prosecutors on how these biases do directly show up in their work, not just in the aggregate, but also directly when they're making these decisions.
And Oren, the DA has identified this as a priority area. So what progress has been made so far, and where does the office plan to go in the future?
Yeah, thank you for the question. So I think we've approached this in a number of ways. I think the examples of the policies that you all looked at, the 2018 and 2019 policies, are examples of our use of discretion to implement transparent plea bargaining policies, right? So the idea that we made these policies and they were transparent to ADAs, but also to defense attorneys and defendants and judges and everybody. So in a very opaque process, and one of the areas of the justice system that is least known, removing variables, making more constant or known can be an improvement for the entire system. So that was part of the logic of the 2018 and 2019 policies. I think something else we're excited about is our ongoing internal and external evaluations of policies and practice. So just like we partnered with the Urban Institute on this, we are also partnering with researchers to look at progressive prosecution and racial disparities more broadly, and also to look at plea bargaining even more, right? So that involves trying to clean some of the data that was very dirty, and so dirty that we couldn't even share it with Urban, right? So really redoubling efforts, putting more resources and time and effort into trying to find all the data we have and make it as usable as possible. And then we're also doing internal work, both the Ending Mass Supervision report that Andrea mentioned, and we're also in the process of doing a report to look at racial disparities in the criminal legal system more broadly. So I think just continuing to focus on these issues and look into them and partner with people like Andrea and colleagues at the Urban Institute who are able to investigate this in different ways is really important. And then I also think we are doing ongoing policy work to both improve plea bargaining and try to address racial disparities and structural racism in Philadelphia and in the system here. And that includes areas that weren't necessarily part of this report. So I think Andrea mentioned, like juvenile justice reform, right? We are doing reform right now in juvenile diversion, and we've partnered with researchers at Drexel to look at the impact of those reforms on reducing racial disparities. Similarly, we have done work in the adult diversion space, and that would mean that a lot of the people that we've diverted, they wouldn't be included in the analysis potentially because their cases didn't make it to the Court of Common Pleas. So just kind of thinking more broadly about some of the other policies that we're doing that might not have been the focus of this effort, but that are also, I think, in the same area and addressing some of the same issues. And then I think the last point I'll make, and Andrea made this as well, is understanding that disparities come in at the point of arrest, and you have these structural racism to the tune that African Americans are overrepresented among arrestees in 94% of the census tracts in Philadelphia, right? So if you have those disparities at the point of arrest, really understanding who is arrested, what were they arrested for, and the role of historical practices and prior record scores in influencing plea bargain offers and decision-making today. So really looking holistically and trying to understand all these different factors that play in to the plea bargaining process so we can improve them.
Yeah, thanks. Thanks for reviewing that. That's all seems, like great work. And it's great to hear about the researcher practitioner partnership aspect of it and trying to evaluate those efforts and getting more robust data systems to look into it. Of course, we know that the most well-intentioned reform efforts may have unintended effects of actually increasing disparities in the system. So really being intentional about that moving forward. So this, I'm excited to hear how that work unfolds in the future. So Andrea, I mean, I wanted to ask, I know that a lot of times as a researcher myself, doing research often, raises more questions and perhaps answers them. So I wondered what unanswered questions do you still have based on the report findings and what you saw as some of the data limitations, through this work?
Yeah, I think this was an exploratory study. It's the first of its kind, as far as I know, to understand how plea bargaining works for prosecutors and what that decision making looks like. So it's obviously led to a lot of follow-up questions. One, for example, and I mentioned this in my presentation, assessing whether prosecutors are actually fulfilling the goals that they've identified for plea bargaining. Are they actually providing justice for defendants, victims in their community? It's a big question, but it does have large implications on practices. As for limitations of the data, there's foundational elements that are missing in plea bargaining data, both in Philadelphia, but as Warren mentioned, and I want to reiterate, in prosecutor offices across the country. There isn't a culture of recording data in prosecutor offices like there is in other fields. And there's certain metrics that we just don't consistently know. Like, for example, how many offers are made on a case? What are the differences between each offer? When were these offers made? And how do prosecutors calculate what these offers would be? These are key aspects of plea bargaining that we still need to know on a larger level. And we got a smaller glimpse at this through our case file review, but there needs to be more universal recording of this information to actually rigorously understand what's happening.
And Steve and Chris, do you have any unanswered questions or things that you would have liked to have been answered that weren't necessarily because of these data limitations that Andrea is mentioning?
Yes, I do. And what struck me most was that when you write these sentencing guidelines, when the sentencing guidelines are written, or the office policies, office-wide policies, some research is done in connection with these things regarding potential or likely outcomes and impact. And it's like the legislative intent. When the legislature authors a piece of law or introduces a statute, there's legislative intent connected to that. In other words, there's some discussion about, what they intend to achieve with some of these things. And I'm concerned about, how do we get to that information regarding the sentencing guidelines, since they play such a major role in this decision-making process? How do we get to that information? And are we getting to that information? Or are we getting to it in a way that will inform us about what that intent was? I mean, of course, we discussed about how the implicit bias and the structural racism might be woven into the fabric of many of these policies or guidelines. And yet we're not exposing the rawness of the guideline, why it was written, how it was written, what its goal or aim was. We're just not taking that apart. And so therefore we're not challenging it correctly.
Right. So digging deeper on those guidelines.
Yeah. Well, we're looking at the DAs who are there, of course, and they're the ones offering the pleas. But we've already heard them say that they're constrained in many ways by these policies, and they can only do. They may wish to do more, but can't, because of those policies, those supervisory concerns. There are a lot of different things going on. And I think that, I would personally like to see more in that area.
Great. Chris, any thoughts on that question?
I mean, not anything beyond what Warren and Stephen have already said.
Great. So I'm going to move on to the next set of questions then, and this is the final set, and then hopefully we should have a little bit of time for some audience questions if any others come in. But the report really has shed light on some realities of using plea bargaining as a system for handling the vast majority of criminal cases. just to kind of review it, found that Philadelphia prosecutors have immense discretion in their decision making, and that plea bargaining can be affected by a wide range of both legal and extra legal factors. It also found that people who decline a plea are more likely to face a custodial sentence or longer incarceration and probation. And although plea bargaining might increase efficiency for prosecutors' offices, people who had accepted pleas interviewed for the study shared that it can really be coercive, fails to treat people like individuals, can be extremely difficult for them to navigate, and can take a terrible toll on the people who go through it. So, Andrea, taking a step back, what overall reflections do you have on plea bargaining as a way of organizing the criminal legal system, both in Philly but also more broadly?
Yeah, what we're seeing in today's criminal legal system across country is an overwhelmed, bloated, unmanageable system. We have a problem of mass criminal legal system involvement, mass incarceration in this country. But because we have such high caseloads, several criminal legal system actors, prosecutors, judges, there's several actors that make decisions that are partially based on efficiency. Part of this is about disposing of cases quickly. However, this can come to the detriment of fairness and foundational rights like we have to the right of trial. So how do we rectify this? I think it's a big question. One thing that comes to mind is we need to shrink the number of people going through the system if we want to treat people like individuals. We have too overwhelmed of a system to actually provide justice for each individual.
And Warren, what lesson should the DAO take from the study?
I think there's a lot to learn. A lot of it has been, discussed already in terms of the training and what we should be thinking about to constantly be mindful of how to improve training. I think more broadly, just thinking about how supporting research like this is a part of reform, and it's good to support research and collaborate with the Urban Institute and other foundations and researchers to open the black box of prosecutorial offices and plea bargaining and other issues too. I think we also, just to underscore again, the lack of data is a problem for reform, right? And it's maybe an irony that we might need more resources to collect better data in order to better do reform and keep as many people as possible away from the system so we can focus on the most serious cases, right? So to reduce the impact of the system on people's lives, you might need, non-lawyers who are data people to complement the lawyers, so the lawyers can do what they've been trained to do, which is consider the facts and weigh the legal decisions that need to be made. And data people can do some of the data work. And really, the city, our office, has never invested in a case management system like so many other jurisdictions that would allow us to collect good plea bargaining data. And we've tried over the past few years to do it, but there's just really years of technological debt to dig out of. And it's hard to do, but it's really worth doing. And that means, because it's hard to do and there's a lot to do, got to start sooner, right? If we ever want to get there. Right. So really just being intentional about that. I think data sharing is like a separate issue, right? So just like MacArthur and ISLG were able to, work to share data and make data available for purposes of this research, data sharing more broadly among different agencies in a jurisdiction is really important. And that can also be important for data quality, right? To reduce the overall work that is needed by a jurisdiction to get meaningful data. Just as an example, which agency in Philadelphia allows people to self-identify their race? Are they making that information available to all the agencies? So all the agencies can have that variable where people are able to self-identify their race. And I think that's kind of like an example of the broader questions that jurisdictions need to address. I think, until data is more broadly available, including hopefully from other prosecutorial offices in Pennsylvania and in other jurisdictions, other states. I think one of the takeaways is that being the most transparent is both good and bad, right? Like when you're the only or one of the few offices, as Chris said, that is engaging in research, then that can be used by all sorts of people who might want to take part of it and zoom in on it or magnify it and not acknowledge that, it's part of the learning process. And when you don't change as much, there's not as much to learn. But when you try to change a lot, it's really important to be open to transparency and accountability that comes with it, because important stakeholders, whether they be people who have experience with the system or advocates, activists, allies, community members, hopefully can recognize that, even though not everything is perfect, even when we make mistakes and trying to change things, we're actually trying to learn from it and be reflexive and introspective about it so that we can improve. And I think that's just something, I brought a prop. I think that's something we could all do better with. This book was very influential for me. I used to assign it to my students, Trial and Error in Criminal Justice Reform, Learning from Mistakes, Learning from Failure by Greg Berman and Aubrey Fox. And I think that's kind of the spirit that it would be helpful to think about a lot of this work and a lot of this research. Again, it's not always going to be perfect. But just kind of striving to continuously make things better is one of the takeaways that, I hope we will have here. And just in general, really appreciate the report. And I also hope that we'll be able to support many more reports like this.
Great, thank you. Chris, I wanted to ask you a similar question, but what lessons should advocates take from the research, the study, the partnership?
I think one of the big things is that sort of illustrated by this research is just the power that DAs and ADAs have. We don't generally talk a lot about the power that DAs have, especially in the reform space. There's a lot of talk about changing these various things like sentencing guidelines, even judges. That there need to be better representation of people who are going through the system, but there's also just a lot of power that DAs have.
Yes.
A lot of things that are possible when there are DAs who actually want people to spend less time in prison. And so I think just really recognizing that and I don't want to say targeting DAs, but sort of keeping that in mind in our advocacy. That we don't want to leave this office, this person who has an enormous amount of power, without some pressure, without some
checks and balances,
push to actually improve what it is that they can.
Yeah, that's a great point. Thank you for weighing in on that. And then finally, the last question that we have, but I think is, a really important one is I wanted to address this to you, Steve. But in your view, what needs to be changed to reduce the harm that plea bargaining can inflict on people that are in the legal system?
Well, Andrea, pardon me, Jennifer, to that question, it's really a hard question. I don't have a definitive answer to that particular point that you've made. However, I do see a trend, and the trend is heavy in Philadelphia, where we need to pay attention to communities. We have been for so long just going along. The justice system or the criminal system does what it does. The attorneys, the judges, the policymakers, the decision makers, they do everything that they need to do that they think is right and that they believe is part of the process and that will be helpful, and they're doing their jobs. However, the community wants in. And I think with the community, you're finding that they want to be engaged, they want to know, they want to understand what is happening, what's going on. After all, that's where folks are coming from. They're coming from the community. And because they're coming from the community is saying, hey, we can hold folks accountable in ways that you may not be able to. And one of the things by the community getting engaged and getting to know some of the actors and the players and the people who are involved can present other options and can present other opportunities for folks in the community. So we need to really pay closer attention to community groups and organizations that are arising rapidly, particularly in Philadelphia, and try to figure out how can they fit into this process. What levels of accountability do they offer for folks who are returning back to the community? The folks that we're going to see, these are the folks that they're going to see every day, So I think that community is something that we need to focus on a little bit more, and we need to have conversations. We need to talk. We need to see where they're going, what they're trying to do, how they're trying to do it, and how they can be assisted or directed in some instances. I'm not saying that the guidance is perfect, but the communication will allow us to to come together and have better guidance on these issues. I'm sorry I can't answer the question that you had for me in a way that I would be satisfied with. So.
No, you're right. It's a big question, an important question, but I think just emphasizing the need for more authentic community engagements in these efforts is very important, and something that we're really trying to prioritize in research efforts as well. So thank you for that. So just in looking at the time, I'm going to pass it over to Lee Courtney, a researcher at Urban, who also was a part of this work. I believe there might be one question from the audience that we have time for, and then she's going to also just kind of summarize the day's discussion and wrap us up. But I really want to thank you all, so far for such an engaging discussion. So Lee?
Thanks, Jennifer. And I do know that we're short on time, so we'll probably need to keep this very brief, but I did want to share one particular question that surfaced in case anyone here, especially maybe Chris or Steve, based on your experience, might want to address. The question is, what role do defense attorneys have in helping to prevent abuses of the plea bargaining system, specifically as it relates to innocent defendants? If you have any brief thoughts, perhaps we could cover that before we wrap up. Steve, do you want to jump in first?
Well, I'll be very brief and short with that. I think that attorneys can be more transparent with their clients, about plea offers and information involved in the case. Oftentimes, folks are entering into pleas and they don't understand the information or the evidence against them. They don't understand the charges. They don't understand where the charges came from. They have all of these ancillary charges connected to one. If it's a gun, you get VUFA, you get a PIC, you get there's carrying without a license in the city, and all of these things are connected to the same event, the same circumstance. Yet the amount of time that's presented, that can be used as a weapon, is astronomical. So just for that one instance or circumstance, a person could be facing, 20, 25 years or more. And that makes the plea look so attractive. It looks so attractive if, someone comes into the room and says, hey, you're facing 25 years, man, and this is what's going on. You got 3 charges, and this is what. And they said, well, listen, they're willing to give you 2 to 4 or 3 to 6, and this is before you've seen any of the evidence or the information that's been lodged against you. So attorneys need to be more transparent about the discovery, about what's on the table, and what their options are. I hope I covered some of it, Lee.
You did. Thank you so much, Steve. Chris, any final thoughts, or should we wrap?
I think what's hard is that defense attorneys have a duty to their individual clients. I think part of what is hard about this issue is that it is systemic. And so it's hard to have a duty to this one person who could have is going to have these enormous life consequences, whether or not they move forward with accepting a plea or go to trial and, you know, have to deal with the consequences of that one way or another, versus like it then doesn't become just like this question of what is fair and like what are these pleas looking like as a whole. It's like much more about like this individual and like how to make the situation the best possible, the best possible outcome for them. And so I think that there is some role, but I think it's nuanced and like really hard.
Well, thank you so much. I know we're officially over time, so I'll just go ahead and say thank you everyone so much for joining us today. What a rich discussion. We covered so many important topics about the importance of more research in this space, but additionally broader reform to touch all the parts of the system that affect plea bargaining and the people involved in it. So just really want to express gratitude for the Institute for State and Local Governance, the MacArthur Foundation for all your support. Thanks again to Oren and his team and your entire office for their partnership throughout this effort. Thanks to Jennifer for moderating today. Thank you everyone for attending. Just a few kind of concluding points. I just want to remind everyone that the report is out in case you missed that. It is in the chat, the link to the report. That also includes a fact sheet that summarizes the key points. You can also find it on Urban's website, which is urban.org. It's featured on the homepage. And tomorrow, our communications team is going to be emailing everyone who registered with a link to the report, as well as the webinar recording and the event survey. So thank you all so much for your time. We really appreciate you. Thank you to our panelists so much for your wisdom and insight. And thank you again.
Thanks, everybody. Take care.
Okay, bye-bye.
Thank you.